Expulsion and detention are states' practices which radically alter lives. They profoundly hurt, they damage people. They have huge physical and mental health impacts on their victims. So much so that criminal law, which provides for both in different formats, has evolved strenuous guarantees to ensure that no error is committed. Rules of procedure and evidence have been developed over centuries, starting with the invention of habeas corpus in the 14th century, in order to protect the innocent, even at the cost of allowing a criminal to go free. We believe we owe it to ourselves. Criminal law was for the longest time the most dangerous part of domestic law, as it could lead to execution, torture, and detention. The guarantees of the rights of the defense were developed to reduce the possibility that innocent people would be erroneously convicted. Now, administrative law, essentially developed during the 20th century, was mostly the law of building permits, commercial zoning regulations, and government procurement contracts. It was not a dangerous part of the law, and it developed rules of procedure and evidence similar to those of civil law, not criminal law. However, today, in EU countries and in countries with no death penalty, such as my country, Canada, the administrative judge, and in this case the immigration judge, is the only person who can ultimately send someone to death, torture, and arbitrary detention through a misguided decision to return a migrant to their country of origin or transit. Yet, administrative law still provides little guarantees similar to that criminal law has evolved over time. State authorities are very happy about this laxity of administrative law. They're not constrained by the stringent rules of criminal law. And they always insist that this is a decision to return someone. We're not prosecuting the person, it's not criminal. In criminal law, state discretion in how they treat suspects and convicts has been utterly restricted in order to avoid abuse, which can have terrible consequences. In contrast, administrative discretion leaves state authorities with a particularly wide margin of appreciation. They can decide that the detention and expulsion of a foreigner is warranted if they have suspicion that a person might commit a criminal act. They can decide this using very problematic, unverified sources and unverifiable sources, such as informants or embassy cables, which cannot be put to the test of cross-examination. Moreover, migration has been declared a public threat, and the whole policy field has been securitized over the past 30 years. States can transfer personal information about foreigners to whomever they wish, and the rules relating to privacy mostly do not effectively apply to the administrative infrastructure of immigration authorities. Some states have sent some foreigners to rot in inaccessible camps or far-flung islands. Think Guantanamo, Nauru, Manus Island. Collective expulsion is part of the dream, quotation marks, of many nationalist populist politicians who would like to send all undocumented or undesirable migrants either home or to transit countries with as little procedural hurdles as possible. Too many appeals, we heard this morning, huh? Too many appeals, yeah, right. Tony Blair voiced this model over 15 years ago when he suggested that all asylum seekers in Europe should be sent to centers in countries like, if I remember well, Mauritania and Albania at the time, where the asylum claims could be assessed without the pesky intervention of NGOs, lawyers, international organizations, or other institutions which could slow the process. We have heard recently President Macron echoing the thought with, I think, Libya in mind. The Australian model of stopping the boat through utterly violating the rights of thousands of migrants in the hope of deterring many others is often presented as the model, quotation marks again, to emulate, but is not a long-term solution either. It violates the principle which is at the root of all international human rights law, Immanuel Kant's categorical imperative, and I quote, "Never treat the other only as a means to an end, but always also as an end." End of quote. The Australian policy is only possible in the absence of an Australian constitutional human rights guarantee mechanism, which would allow the judiciary to judge of the constitutionality of immigration policies and practices. Despite so many lives lost or destroyed as a result of stringent prohibition policies, and despite the considerable efforts of some rare institutions, such as the Court of Justice of the European Union, the European Court of Human Rights, several national constitutional courts, FRA, national human rights institutions, ombudspersons, we still have not found a way to provide this policy field with a proper rule of law framework. This is particularly striking in view of the fact that states have acknowledged in the Palermo Protocol on the smuggling of migrants that undocumented and smuggled migrants have committed no crime and should not be prosecuted for being smuggled. How can we not remember that the whole thrust of the human rights movement for the past 70 years has been individualization? All decisions which can affect the rights of any individual need to be made taking into account the specific circumstances of this individual. We have decided that one could not make a decision that would profoundly affect the rights of anyone based on the single fact that they are Jewish or female or gay or disabled or poor. And anyone should have access to a decision maker to ensure that the specific circumstances of their case is effectively taken into account. This is how the rule of law and human rights guarantees work together. Contemporary democracies rest on the tripod of political representation, the rule of law, and human rights guarantees. If any of these three pillars is missing, we do not have a full-fledged democracy. The combination of the rule of law and human rights guarantees has allowed for progress in favor of many marginalized groups in society. But it still does not for migrants because of the fear factor I mentioned this morning. Migrants constantly exercise agency, considerable agency, often have underground support networks, and they make life-altering decisions on a regular basis. Taking the metro can be a life-altering decision if you're caught and detained for months and then deported. But migrants rarely publicly protest, contest, organize, unionize, mobilize, or go to court. Sticking their neck out may mean being detected by the authorities as undocumented or identified by the employer as a troublemaker, the consequence of which may be detention and deportation. Repression creates fear, which is part of the strategy. Young migrants, their families and communities have most often invested beyond their means in the migration project. They often undertake this migration project guided by a sense of duty towards their family. They have the moral high ground of any survival strategy. Anything that threatens the migration project, such as speaking up, protesting, unionizing, fighting for your rights, is thus dangerous. Rather than going to court, moving on is often the preferred strategy. Some of them will indeed fight their deportation, but many states have found strategies to make this difficult. In some countries, there are no de jure appeals, but only judicial control. That's the case of Canada, which does not allow the judge to review the assessment of facts, only questions of law. In other countries, migrants are detained in centers which are far from the downtown area, thus mostly inaccessible to lawyers, NGOs, or family. In many countries, legal aid is simply not available, or the amounts are so small that lawyers cannot do a proper job. Interpretation services are often neglected, leading to irreparable misunderstandings. Many states will also concede the case of any migrant who is well defended, for two reasons. One, conceding and providing this migrant with a minimal status avoids the establishment of any precedent which would bind them in the future. Two, they realize it's better to concentrate their resources on all the other migrants who are not well defended and can be deported without much difficulty. Most often, the deportation statistics will count more than the individual reasoning. Considering the number of cases in which migrants would be in need of legal services, states have not invested nearly enough to ensure that justice is effectively accessible to migrants. And it is also part of that strategy. Access to justice is already difficult for citizens. It has become almost impossible for most migrants. If all the migrants who are exploited at work or detained or expelled or trafficked went to court, our justice systems would crumble under the weight. Because migrants stay mum, we citizens do not realize the amplitude of the issue. And many unofficial practices happen at the border, at sea, in airports, in detention centers, which remain under the radar of accountability mechanisms and judicial institutions. Without political participation, the judiciary is the only line of defense against migrants' human rights violations. Lawyers and judges have had to educate themselves over the past 30 years on issues they were not really familiar with. As happened with criminal law, and considering the consequences of detention and deportation to the well-being of any person, administrative judges will have, over the coming decades, to restrict considerably administrative discretion and oblige states to provide very specific justifications, thus strikingly reducing their margin of appreciation. This happened in the past when criminal courts protected the procedural rights of the accused, often infuriating the prosecutors. The same will have to be done in favor of migrants in the administrative law realm. Rules of evidence and procedure will have to be considerably strengthened beyond the fairness principle in order to match the threat to the migrants' well-being. This is already underway. The Charter of Fundamental Rights of the EU has extended the right to fair procedures. The right to a fair trial is usually in most constitutions reserved to criminal procedures, but in the Charter of Fundamental Rights, this right to fair procedures has been extended to all persons whose rights are at stake, not simply in criminal law. In Europe, in North America, and elsewhere, judges will have to go beyond the reluctance to challenge the state on an issue it has defined as relating to sovereignty and security. This will not be judicial activism, but the progressive requirement of legal coherence in a field which threatens the rights and freedoms of individuals as much, if not more nowadays, than criminal law. Considering migrants as full-fledged rights holders will require courage, imagination, and determination on the part of the lawyers and the judiciary and other actors such as national human rights institutions and ombudspersons. Millions of people are counting on them. Many thanks for your kind attention.